Ever received a withdrawal request from a customer and panicked about what to do next? In the EU, getting this wrong can cost you far more than one refund. But with the right steps, it's a smooth, trust-building process every time. First, a disclaimer. This video is for informational purposes only and does not constitute legal advice. If you would like personalized guidance, you can contact our team or other qualified professionals. Hey everyone, Robert here, legal consultant, licensed tax advisor and founder of Kyroptero Consulting based in beautiful Slovenia. We've helped countless e-commerce businesses navigate EU consumer rules with confidence. Today, we're breaking down exactly what the Consumer Rights Directive requires from you, your online shop, when it comes to the right of withdrawal. Let's make sure your store is legally bulletproof and your customers keep coming back. Your customer clicked buy now. The package arrived and now they want to return it. Sounds familiar? Under the EU Consumer Rights Directive, the CRD, every consumer buying from your online store has a statutory 14-day right of withdrawal. That means they can cancel the contract, no reason required, and you must handle it correctly. The good news, a smooth withdrawal process is one of the best trust signals you can send. Your online store is selling under what the CRD calls a distant contract. Any sale concluded without face-to-face contact through your website, app, or other remote means. This triggers the full set of CRD obligations for your business. Miss them and the consequences are automatic and costly. Let's walk through your obligations step by step. Your first and most critical obligation is pre-contractual disclosure. Before the customer clicks buy, your website must clearly inform them that the right of withdrawal exists, how long it lasts, and how to exercise it. This information must appear before the order is confirmed, not buried in your terms and conditions, not hidden in a footer. The most efficient way to do this? Use the official EU model withdrawal form and link it directly on your product pages and at checkout. You are legally required to provide it, so make it easy to find. Here is why this matters so much. If you fail to inform the consumer before the sale, their 14-day window automatically extends to a total of 12 months and 14 days from receipt of the goods. That is a potential 12.5-month return window on every single order you ship, triggered purely by a missing sentence on your checkout page. Pre-contractual disclosure checklist. First, state the 14-day right of withdrawal clearly at checkout. Second, provide or link the official EU model cancellation form. Third, explain who pays return shipping costs and state the amount or a reasonable estimate. And finally, confirm this in your order confirmation email. A customer sends you a withdrawal notice. What do? First, accept it. The customer has 14 days from receipt of the goods to notify you, and they can do so by any clear statement. An email, your online cancellation form, or even a phone call. You cannot require a specific format beyond a clear statement. Here's a pro tip for making it this far in the video. Offer a one-click cancellation button directly in the customer's account area. This reduces disputes, creates automatic proof of the withdrawal date, and signals professionalism. You're not legally required to provide one under the current CRD, but it is best practice and incoming EU reforms are likely to make it mandatory. Once you receive the notice, you have 14 days to issue the full refund, including the original standard delivery cost. You can use the same payment method the customer used, and you cannot charge any fee for the refund itself. You're allowed to withhold the refund until you receive the goods back or until the customer provides proof of shipment, whichever comes first. So make sure your returns process generates tracking confirmation quickly. Let's talk money. Your refund must cover the full purchase price plus standard delivery costs. If the customer originally chose a premium delivery option, you only refund the standard rate, the cheapest you offered. You keep the difference. Can you deduct anything from the refund? Yes, but only under specific conditions. If the customer handled the goods beyond what would be reasonable in a physical store, trying on a jacket is fine, but wearing it for a week and washing it is not, you are entitled to deduct the loss in value from the refund. However, this deduction is only lawful if you explicitly inform the consumer of this liability before the sale. No prior disclosure means no deduction. Full stop. On the practical side of things, always photograph and document returned items upon arrival to substantiate any deduction you apply. One important caveat, though, the CRD sets a minimum standard, and member states have some flexibility in how they implement and enforce it. In some jurisdictions, local regulators or courts have taken the position that the seller must first issue a full refund and then pursue the consumer separately for the diminished value, rather than offsetting it directly. Before building your return policy, check the specific practices and regulatory guidance in each market you sell into. Who pays return shipping? By default, you do, unless you clearly informed the customer before the sale that they bear the return costs and provided the exact amount or a reasonable estimate. If that information was missing from your checkout flow, you absorbed the return shipping cost regardless of the item's size or weight. Quick refund obligations recap. Step 1. Refund within 14 days of receiving the withdrawal notice. Step 2. Include standard delivery in the refund. Keep premium delivery surcharge. Step 3. Safe payment method. Zero surcharges. Step 4. Deduct diminished value only if pre-disclosed and documented. And finally, Step 5. Cover return shipping if you fail to inform the customer in advance. Now, not every product in your catalog is subject to the right of withdrawal, and knowing your exceptions protects your margin. The main categories exempt from the right of withdrawal are customs or personalized goods made to the consumer's specifications, perishable goods like food, flowers, anything that deteriorates rapidly, sealed hygiene or health products once they are unsealed after delivery. There are no returns. Sealed audio, video or software once the seal is broken by the consumer. Digital content delivered instantly online, but only if the consumer gave prior express consent to immediate delivery and explicitly acknowledged that with that it forfeits its right of withdrawal. Both conditions must be met and documented. Up next, goods that are inseparably mixed with other items after delivery. For example, a customer mixes a delivered liquid product with something else. Regular delivery of goods, milk rounds, grocery subscriptions delivered at fixed intervals. The exception applies to the supply arrangement, not individual orders. Alcoholic beverages where the price was agreed at contract conclusion, but delivery can only occur after 30 days and the value depends on market fluctuations. Urgent repair or maintenance services where the consumer has specifically requested a visit from the trader for this purpose, though this is more relevant to off-premises contracts. Certain contracts not covered by the CRD at all, like financial services, gambling, package travel, real estate, construction, social services, and healthcare contracts are excluded from the CRD scope entirely, meaning the right of withdrawal under the CRD does not apply. Next up, accommodation, transport, car rental, catering, or leisure services for a specific date. This also includes event tickets. Newspapers and magazines accept subscription contracts. And finally, off-premises contracts below 50 euros. Some member states apply this minimum threshold, though this is a national opt-in under Article 16. A word of warning: do not apply these exceptions broadly or creatively. Regulators and courts interpret them narrowly. If in doubt, treat the product as withdrawal. To sum it up, your CRD right of withdrawal compliance rests on 5 pillars. Inform customers before the sale clearly and visibly. Handle withdrawals requests promptly and without obstruction. Refund in full within 14 days. Safe payment method, no hidden charges. Know your exceptions and apply them only where legally certain. And document everything: your notices, your returns, your refund timestamps. Getting the right of withdrawal right, see what I did there, is not just about avoiding fines. It is about building the kind of customer trust that turns first-time buyers into repeat shoppers. Clean, transparent returns process is your competitive advantage, not your liability. If this helped you tighten up your online shop's compliance, give it a thumbs up, share it with your team, and subscribe for more practical EU compliance insights. Head to our knowledge center, links in the description, for more resources. Thanks for watching, and remember, compliance with the law prevents the flaw. Till next time.